to do a complex estate plan, just add your kids to the title of your house. Add your kids to your accounts. That way, if something happens to you, it goes to them and you don't have to worry about probate. While that's true, that also comes with a lot of other issues.
Hey everybody, welcome back to Wealth Unfiltered. I'm Samantha, I'm your host, and I am very excited today because we have a dear friend on the show. Chris and Erica have actually been friends since college days, and I've had the privilege to know her for about 8 years now. This show we're planning on having here is very powerful for all age ranges. So there is a common misconception that you don't need to start your estate planning until 50s, 60s, and that is just not the case. So I am happy to introduce partner at Dorsey Law Firm here in Florida and dear friend, estate planning attorney Erica Johnson. Welcome.
Thank you. Thank you. Thank you. I'm so glad you touched on that too, because that was one big thing I always like to bring up is that people think that in order to do estate planning, you have to have uber wealth and ultra high net worth or be retiring or sick or something like that. So I'm so happy you touched on that.
I am so excited to have you here. So I think before we really jump into the meat of the topic, getting our audience to know a little bit about you. So if you could tell us, I mean, obviously you decided to be a lawyer, but there are many ways you could have gone. So why estate planning?
That's actually a really funny story. It was by accident, if I'm being totally honest. In fact, it was probably the last area of law that was on my radar. When I went to law school, I had my next door neighbor growing up in Boca was an estate planning attorney, is an estate planning attorney still in Boca. And so when he caught wind that I was going to law school, he was like, perfect, come back to Boca, to your hometown. I can retire, you can take over. And I was like, I don't think so. I always dreamed of something a little bit more, I don't know, energetic, I guess, was kind of, everybody thinks about being an attorney on like the shows you watch and Suits
Right.
and it was during the Suits era and during, Entourage era. And so in my head, I'm going to be, a big bad sports agent or something like that. But I really didn't know what direction I was going to go in law school. I didn't know a lick about estate planning when I graduated. It was really just what I needed to pass the bar. Um, and then I was studying for the bar and I was applying for jobs in Southwest Florida. I had moved here by then studying for the bar. And when I came out of law school in 2012 was right after the economy collapsed. So everybody was trying to do something more than just going to college and getting a bachelor's degree. And truthfully, going to law school is the least additional number of years. There's one test, there's no residency or anything like there is in medicine. And so a ton of people were going to law school just to have something to do. So there were a ton of new attorneys coming out and not enough jobs. And so I was applying and applying and applying, and there was nothing. And, I went on interviews and stuff, but they're probably going to hire at that point somebody with more experience. And so I thought to myself, okay, let me think outside the box. I applied to the one legal-based job that was in Southwest Florida on LinkedIn at the time. It was for a paralegal. And so I was like, well, okay, if I apply for this job, then, maybe if they like me, they'll keep me and I'll be an attorney there. And it was an estate planning firm. And so I went in for my interview and just immediately connected with my managing partner. And he hired me on the spot. I hadn't even gotten my bar results yet. I was getting them the week later. And he's like, you know what? I had no intentions of hiring an attorney. I was looking for a paralegal, but whether you pass the bar or you don't, you've got a job. And a
Oh
week later, I
my
passed
gosh,
the
that's
bar and I was an
awesome.
attorney at an estate planning firm. Um, and, truthfully, like any area of law, the practice of law school is all theoretical. The practice of law is where you start to learn how to practice law once you actually get into it. And so he's been an incredible mentor. I've been here for 12 years and honestly could not have picked a better area of practice for me. I love it. I absolutely love it.
That's so cool. What a fun story.
Kind of by accident.
I love that though. That's so neat. Okay, well, so I think so we touched on how basically that people have a misconception that you should start planning later in life. So I think where I want to start and really kind of diving in is how would you maybe like what would be some advice or from people who are like in their younger years, maybe in their 20s, early 30s, like what phase of estate planning should they be doing versus somebody who would be like in their 50s?
So I mean, our philosophy is everybody over the age of 18 should have some kind of planning. That's obviously going to vary based on, what portfolio they've built, what type of assets they have, what their goals are. But the reality of it isn't just about planning for when you're gone, but over the age of 18, we are our own legal guardians at that point, right? Our parents don't have legal rights to make decisions for us anymore. And I think that's something that gets lost.
Hmm.
And we talk about this a lot with groups, especially for student athletes, is a huge example we use. If a student goes off to college, 18 years old, they're a student athlete, they get hurt on the football field, they have a concussion or something even worse, legally, their parents don't have the rights to make decisions for them anymore.
Hmm.
So even just as simple as having documents in place to ensure that parents or loved ones can make decisions for you in those types of situations, at the most basic level, everybody over 18 should have those.
Okay, I think that's a great starting point. And so let's talk about more too, like you mentioned athletes and kind of something that is newer that has been triggered is athletes in college who are now getting paid, right? So they
Mhm.
have the opportunity to make money. So how would you maybe help somebody in their 20s, maybe even still in college at this point, who actually does have some assets, has a major stream of income coming in and how to
Mhm.
prepare themselves?
I think as early as possible, it's important to get your big three in place. And I call the big three your estate planning attorney, your financial advisor, and your CPA. Everybody likes to go to the turbo taxes and the easy filings because they're cheaper and they're quicker and you can do it yourself, but you get what you pay for.
Yeah.
So CPAs are, I think they're left kind of out of the loop more than they should be. And having those big three in your circle and working together as early as possible is probably the most beneficial, because they all provide expertise on all those areas, on taxes, on investing, on planning. And so I think it's a wise decision to start as you start to make money, stop worrying about the fact that you're making money and make sure you're protecting that money, and utilizing it the best way possible. And I think it's more of just an education issue with some of the younger generations. I remember at 18 years old, if I was getting paid significant amount of money for being in sports or whatever it was, I mean, probably would have blown it
Right.
unless somebody educated me otherwise. And I think outside of athletes, one thing I would always encourage from personal experience is if you are a younger professional and you are in a job or a situation where you have benefits, take advantage of those benefits immediately when you can. I didn't think much about it when I first started practicing law, and I wasted 5 years before I started contributing to my 401k.
Right.
So and it would have been exponentially higher now than it is. So I mean, I think just if we can somehow figure out how to educate these younger generations better on how easy it is to build wealth faster than they think, I mean that would be a game changer for them.
Absolutely. Yeah, I think that's probably one of the things that Chris and I touch on frequently in every single episode is like, I think a lot of times people feel like you can't start creating your wealth until after you have like a really long-term established career,
Yeah.
something like in your early 40s. Oh, now I can start saving. But I think the benefit to utilizing the 401k or any option that your company gives you right away is that you're already compounding that interest, you're compounding your wealth, you're creating something better for yourself without putting an extra job in extra hours, you know?
Yeah.
So I think that absolutely, I think you're 100% correct there. One of the things that I wanted to touch on, talking about building wealth is there's a transition that happens in most people's lives, whether it's they get married or they don't get married, but they have children. So when you start growing family and building that out, what are some of the things that you would say change from being a single person to now you either have a partner or a spouse and or children? What's the flip there? What's some of your advice for that?
Yeah, that's a good question. I think as single individuals, we tend to have a little bit more ability to be riskier, right? Because it's just about us at that point. So I think that mindset, it's probably a pretty common shift, but I think there's a shift in how conservative investments are at that point. especially when children are involved. There are so many opportunities out there for investing and planning for them. 529 tuition plans. Another one, start early and you would be so surprised at how big that can grow and how much you can have. You never have to worry about college tuition.
Right.
So making sure you're using your financial advisor, not just waiting for that annual call and checkup to say, hey, how are things? Great, cool. See you next year. Use your financial planners. That's what they're there for. Encourage the conversation as much as possible to figure out how to shift, where you're investing and how your growth versus, risk versus reward and your growth versus, conservation. And I think it's important to just always keep the conversation going. From a planning perspective, again, I mean, I think a lot of parents think about this, but when you have minor children, who's going to take care of them when you're gone?
Right.
Something happens to you, anybody can come into the court and say, hey, I want to be their guardian. All blood relatives are treated the same. So it's important to plan even something that minor. Plan something to have in place. There are documents you can have in place in Florida. They go on record with the court, and God forbid anything ever happens to mom and dad, the court knows who the kids are going to, and nobody has to fight about it.
Right.
So it's just making it easier, planning ahead as much as possible, no matter how minor the planning is. It doesn't have to be some giant complex estate plan to be protecting and preserving, family legacies and your loved ones.
I would say
Um,
that's something that people probably shy away from because I think there's two things that probably come into play. One is a fear of even like that even coming to fruition, right? So
yeah.
people, it's the like, it's not going to happen to me syndrome. So like people are like, when I'm in my 80s or when I'm in my 60s,
Mhm.
but then there's also the piece of the financial burden, right? So I think people just assume they hear the word attorney, they hear the word like a lawyer, and they're like, I see dollar signs. I don't want to do this, right? So maybe you could talk a little bit about what small steps that people could take that aren't going to be a huge financial burden for anybody, and then like
Yeah.
how then you would grow your plan, maybe with your wealth.
Yeah. That's a good question. And I think a lot of people would agree with that, if I go and see an attorney to do an estate plan, it's going to cost me thousands or tens of thousands of dollars. But an estate plan, a full estate plan includes a lot of pieces. So
Mhm.
there's nothing that says you can't just do it a la carte, do it in phases, spend what you're comfortable spending just to get started and add to it as time goes on, as you feel more comfortable spending the money. But again, it comes down to the return on your investment. You're making an investment in your family by doing estate planning early. Not only can you protect them from having to go through the court process and probate and that expense, going through family fighting over stuff, creating, barriers between family members, rifts between siblings, which we see all the time. So there's a huge return on the investment that you're putting into it, just to plan ahead and make things easier for your family if something happens to you.
Yeah, no, absolutely. I'm sure you remember, but my family, we've owned and operated funeral homes my entire life.
Mhm.
And watching the chaos that ensues when
Yes.
somebody dies and has not taken the steps to either have a will or some type of planning in place is literal chaos. Like, I mean, even just how would you do the burial? Are they going to be cremated? Or are they going to be, put in the ground? Like, those are like the fundamentals of what has to happen. And then you talk about the estate and you talk about what they are going to get after the fact. I mean, death makes people really ugly with each other, and
It
it should be
does.
a time of like getting closer and being bonded, but it like sometimes it rips people apart. So I
It
feel like
does.
that's like our duties to our family to wrap that up, like put a bow
Yep.
on it for them.
Yeah, and I mean, and that's the reality. I see it every day. There's no middle ground. When somebody dies, it either pulls the family closer or rips them apart.
Yeah.
And I have seen, I've had clients for, the 12 years I've been in practice. From then until now, I've seen families completely destroyed. I've seen kids disinherited. I've seen people disowning each other. And it's just because, there's no planning ahead of time or enough planning ahead of time that then, families come to us and we have to probate an estate and everybody's up in arms about it. So yeah, I mean, we see a lot. We've had many slam doors and people get up and walk out and
I bet. Gosh, I imagine it's a high stress environment.
it is. It is. And I mean, the reality is, like you said, nobody likes to talk about death. Nobody likes to talk about disability. So, our firm, we try to approach it from a more it's going to be an odd word to use, but from a more lighthearted standpoint,
Hmm.
where it's not so glum and depressing. It's more about taking care of your family rather than, you're dying, what are you going to do?
Right.
So we try to approach it more from that aspect. And I think if people start to think about it that way, I've created this legacy, I've built all this wealth, I've worked my whole life for it. I want to protect my family, I want to protect my loved ones.
Right.
It sort of changes and shifts the mindset a little bit.
Absolutely. No, I totally agree with that. Um, One of the things that people know, obviously, I think the most common word used when people think about this is a will. But
Mhm.
what are some of your opinions, or when should people use a trust? When should a family use a trust versus a business? Like, what are some of your insights or advice you have when people really do start establishing their wealth?
Yeah. A will-based plan is always a good place to start. And, trust is not a one size fits all for everybody. Sometimes a will is perfectly acceptable depending on what somebody's goals are. One of our primary driving focuses for all of our clients is avoiding the probate process,
Hmm.
which is what a will does. So there's this common misconception out there that if I have a last will and testament, my assets are not going to go through probate. The court doesn't get involved because I have designated in my will where everything is supposed to go. But it's actually the opposite in reality. A will is guaranteeing a probate. If you want your assets to be distributed via a will, it has to go through probate. So if somebody does a will-based plan, we try to utilize a will more as a safety net in case they haven't prepared elsewhere. And we'll encourage them to go to the bank and their investment firms and make sure all retirement assets and life insurance and brokerage accounts, everything has a beneficiary on it. If it has a beneficiary, those assets will stay outside of probate. So we try to minimize probate as much as we possibly can, and we encourage them to do that. Trusts, we do far more of for a number of reasons, probate avoidance purposes, of course. And then as goals change and as assets grow, trusts also provide the ability to offer more protection. So you can protect surviving spouse, you can protect beneficiaries from things like bankruptcy or divorce or lawsuits or creditors who have a judgment against them. We have the ability to set trusts up to provide that the inheritance to these beneficiaries can be protected from their own creditors. And that's kind of trust planning on its more basic level for us, what I would call our general estate planning. And then it gets further down the road. If there's estate tax issues, if there's asset protection issues, if there's long-term care planning issues, then we start adding in more and more trusts. Typically, those more complex trusts would be irrevocable versus revocable, right? Can't be changed versus can be changed. Irrevocable trusts add a lot of additional protections for very specific purposes: state taxes, long-term care planning, asset protection planning. So it really, I mean, there's no one size fits all plan. I prefer clients to do trusts because I know that they're going to get something better on the back end out of it.
Hmm.
Um, for most of my clients, what would keep them from doing a trust versus, and actually going with will-based planning is just cost. I mean, the reality is the cost of a will-based plan is less because they're not as complex. And sometimes that's a bigger concern for clients, and that's okay. We just try to educate them on, how to best utilize the plan that they've chose.
That makes a ton of sense. With that, okay, so thinking about our listeners, a lot of what we have, we have a ton of people who listen because of Chris's job at Viking Capital, specifically to be real estate investors. So whether they're passive or they're active real estate, they have portfolios that they're generating this extra income, and they have several properties. I'm sure will be in LLCs, some will be under their name. I mean, that's just another dynamic to it. But when you're talking about somebody who has like a large real estate portfolio, would there be a specific way that you would encourage people to help when it is time to like plan for their heirs?
Yeah, absolutely. So that's twofold. So first of all, I would say for our real estate investors, our real estate investor clients, we strongly recommend utilizing LLCs for
Okay.
asset protection purposes. Especially in Florida, your primary residence is protected, but if you were to ever be personally sued during your lifetime, any real estate you have that's a secondary home, a rental, those are all up for grabs.
Mhm.
So we structure our real estate investors in what we call our hub and spoke approach. So we create a parent company.
Mhm.
It could be under Florida. Sometimes we'll utilize other states based on their asset protection, like Wyoming, South Dakota, Nevada. But we'll create a parent company, which is the management company or the finance company, and then it will hold subsidiaries.
Okay.
Each subsidiary will own its own, ideally, will own its own piece of real estate. So we're limiting out their liability
Mhm.
into one particular LLC holding property. So if they have a tenant that sues them for any number of reasons, the only asset that's up for grabs is going to be that one particular piece of property. So
Yeah.
that's how we try to encourage our real estate investors to plan during lifetime. And then upon death, we just do a transfer on death of the parent company into a trust, and the entire structure is in a trust at that point.
Okay.
Um, when it's a little bit different when it comes to individually owned real estate for investors, we discourage that as much as possible. For anybody listening, if you own a lot of real estate in your own personal name and it's all rental properties, we need to have a conversation. Um, but when it comes to real estate, trusts become a huge asset because if somebody passes away, any place that they own real estate, any state where they own real estate subjects them to probate. So let's say, I die, I live in Florida, it's my domicile. I own property in Montana, I own property in North Carolina, I own property in Kentucky. If I don't have the proper estate plan set up, I have a probate in Florida because I live here. I have a probate in Montana because I have property there, probate in Kentucky, probate in North Carolina. So you're compounding time, money, expense, all of that, multiple states simply because you owned real property there and you didn't plan.
Wow. Yeah, yeah. Okay. So I hope everyone hears her. Don't put it in your name. Use an LLC.
Yes, if you have multiple pieces of rental real estate and they're owned individually, let's have a discussion.
Oh, that's so good. No, great advice. I think hopefully I know that we tell our investors to make sure that they use LLCs for the most part, especially
Yes.
because they're investing with us as a company, as a larger company, right? But I definitely see how many people who have the active portfolios and are doing the rentals themselves could find themselves with an issue even if they maybe just had one LLC and then they were trying to use that for everyone instead of the way you were
Yes.
describing it as individual. I think that could be a big mistake.
Hmm.
So on that mistakes, I wanted to ask you, what are probably like the three most common mistakes that you see? And it doesn't have to be necessarily real estate related, but just in estate planning that you would say, like, let's steer away from this.
Oh, that is such a good question. And actually, one of the big ones does involve real estate. So we have many times, and I'll share a story about this. So we have many times gotten clients who have received advice from somebody on the golf course or by the pool or a pickleball court that says, oh, you don't need to do a complex estate plan. Just add your kids to the title of your house, add your kids to your accounts. That way, if something happens to you, it goes to them and you don't have to worry about probate. While that's true, that also comes with a lot of other issues. So, for example, real estate, if I were to add my kids as owners of my house now, for tax purposes, they get a lateral cost basis. Okay. So their value of the property is what it is right now.
Mhm.
So if I die, they have the same cost basis. If they turn around and sell it, they're paying capital gains based on my cost basis.
Right.
Whereas if we set it up where they only receive the property upon death, in still a probate avoidance technique, they receive it upon death, they get a step up in cost basis.
Mhm.
So they get my date of death value, which typically would be higher. If they turned around and sold it, they'd pay virtually no capital gains or very little capital gains. So there's a
Right.
really big tax consequence by adding kids to your house. Um, we also get a lot of people who add them on to their own accounts, which is also a big problem for different purposes. So we actually had a client a couple of years ago. He had gotten this advice and he came to us and had added his son on his brokerage accounts, his bank accounts, whatever he could for probate avoidance purposes. And his son was embarrassed to tell dad that he filed for Chapter 13 bankruptcy. So
Oh,
all of dad's accounts were completely frozen during the bankruptcy.
I
And he
bet.
had to spend $30,000, $40,000 to prove to the bankruptcy trustee that these were in fact his accounts, not his son's. So it turned out okay, but he expended $30,000,
Jeez.
$40,000 to try to get his own money back.
When you think you're doing something right. Ow.
And it's not an uncommon thing. People estate planning has evolved so much. So, when retirees now are out on the golf course or spending time with their friends, they're talking about the advice that they got, 30 years ago, which
Right.
maybe back then was okay, but it has evolved so much that I discourage if anybody gets advice from a non-estate planning attorney on what to do, you can certainly take it into consideration, but bring it to an attorney, bring it to an estate planning attorney, let them know what you're trying to do and what you heard as an option, and they will probably discourage you from doing that.
Yeah.
But they'll at least be able to provide you alternatives to reach the same goal.
Wow. Yeah. No, I can imagine that he took that and was like zero advice ever from a golf course again. Like,
Yes. Unless it's an estate planning attorney, which is fine, I will accept that. But yeah, if you're just talking to a buddy or something, I would, try to make sure you have all options available to you before you just go and do something.
wow. Yeah.
Yeah.
Good story. Man,
That's always a
I'm
fun one.
like, really, I was a little like taken back. I'm like, I don't know if I have words after that one. That's a big deal. Poor guy.
I know, it's terrible. Um, Other estate planning myths, I know I talked about one a little bit earlier. There's because we're all at this point our own legal guardians, we always get the assumption, well, I mean, if something happens to me, my spouse can just make decisions for me, right? And it's not. In Florida, spouse and all blood relatives are treated the same. So unless everybody agrees when something happens, you're going to be at an impasse. And I'm sure a lot of people on this podcast, especially if they're in Florida, remember Terry Schiavo back in the early 2000s. She was in her 20s, suffered cardiac arrest in her 20s, and was on life support. And her husband wanted to end her suffering and remove life support, and her parents did not. They didn't want to let her go. And nobody could agree. She didn't have any estate planning in place. So she remained on life support for over a decade. And it was only until Governor Jeb Bush removed her from life support in the early 2000s. He happened to agree with the husband, but because she was a ward of the state, she had nobody to be her guardian. The governor became her default guardian and made the decision. So it's important. Don't make the assumption that spouse can make decisions for you or kids can make decisions for you.
I
That's a
think
really
that's
big one.
also like something that you just said that really sparked something in me because I feel like what happens is people relocate and they just
Yep.
assume that because there was a law in the state they were in before that it moves over or it just, oh, where I'm in the US, it has to be the same. And it's just not the case. Like state to
Nope.
state, it varies so much. Because
Yep.
I would say out of the last 5 states that I've lived in, three of the five are that way.
Yep.
So it's like you have to really know, is this like where am I living right now? Is that the law? Because for me, obviously, I talk because of where my family is. Like my family openly knows my wishes. Everybody is aligned with everything. And then I'm like, okay, so we have to have a will and we have to do these things. So since I was a
Mhm.
little girl, my mom's like, and you could die at any time. Like that's just like,
Yeah.
right. And so,
Yeah.
but most people don't grow up talking about death. And it's like a very scary thing for them. They don't know how to plan for it. They don't know where to start.
Yep.
And I would say, I outside of just like the will piece, then you have to talk about like your physical assets. You talk about your investments on top of that. How are you going to put those amongst other people? The thing that you just brought up is also about like while you're alive if something medically happens to you, because I think there is also another misconception is that if you put somebody in control of your will or in control of your estate, that they would also automatically be in control of your person, which is not the
Yep.
case, right?
Correct.
So I think maybe you could even touch on like how many different people or what type of assignments that you would really need to do to have like an
Sure.
inclusive of like estate planning.
Yeah, absolutely. So that's one of the things that varies from state to state. Florida, because of our high retiree population, we tend to be a little bit more intricate and regulated with these types of issues. So we actually, for healthcare and financial planning during life, we actually have five separate parts to the plan, five separate statutes, five separate documents that we create to make sure potential incapacity or disability is taken care of. A lot of people think, well, I have to pick my oldest child, or I have to, the same person has to be responsible for everything. And that's not the case. You can do whatever you want,
Mhm.
but it's considering if something were to happen to you and your spouse, if you're married, if you guys can't make decisions for for yourselves or for each other, who do you want to be responsible for making healthcare decisions? Who do you trust to make healthcare decisions? And it doesn't have to be kids. I have plenty of clients that have picked us. I have plenty of clients that have picked siblings or best friends because they don't trust the decisions their kids would make, and that's okay. Um, but
I didn't realize
making
you
that
could pick like a third party, like literally just a
100%.
law firm.
Yeah,
Okay.
100%. You can
I
pick
did not
anybody
know
you
that.
want. Doesn't even have to be a blood relative.
Okay.
We encourage to try to pick somebody, especially depending on what the state's laws are, we try to encourage picking somebody who's geographically close by, especially for health reasons. If something happens to you, we want to make sure they can get there quickly. Reality is now with Zoom and Teams and, everything electronic and, tech we have, it's pretty simple to get any decisions made. But, sometimes it's a good idea to consider somebody geographically close. But yeah, I mean, you pick somebody in your life who you trust would make healthcare decisions. Maybe you have a niece who's an RN and she knows, medicine in and out. For financial purposes, making financial decisions for you. Don't pick the kid who just wants to buy horses. You know, for anybody listening, I ride horses. But you pick somebody who's in the financial industry or just has a frugal head on their shoulders, who just understands the responsibility behind it. So you just think about those types of things, and it can be anybody. It can be really anybody.
What are the five separate legal documents that you were talking about, or like things that you have to have
Good
separate?
question. So in Florida, because it varies state to state, most states combine healthcare directives into one. But in Florida, we have a healthcare surrogate. So that's making sure that somebody can make daily healthcare decisions for you. So you're going into surgery, you get into a car accident. We're not talking about end of life. There's just some need for somebody to step in for you. And in Florida, it has a toggle switch, so you can turn it on and off. It doesn't have to be permanent. Then we have the living will. So if you are in a situation you're not going to recover from, so you have a terminal illness, an irreversible condition, you're in a vegetative state, Alzheimer's, dementia, end stage, you have the ability in Florida to make those decisions for yourself ahead of time in a living will. So you are declaring to your loved ones, if I am not going to recover from my condition and I cannot communicate for myself, this is what I want to happen. And they're very in depth. So you go through an initial everything you want and you don't want. So the burden then is not on your family from having to make those choices for you. Had Terry Schiavo done that, they would have never been in the situation that they were in. They would have known what her wishes were. Then we have a HIPAA waiver, which if anybody listening is familiar with medicine, that's that thing you sign every single time you go to the doctor. Our HIPAA waivers in Florida are legally binding for 24 months, and you can include any family members that you want. So you can include, well, it doesn't even have to be family. You can include anybody you want. So anybody that you want to have access to your medical information, especially those that you're choosing to make decisions for you, you can name as many of those as you want on there. We have a power of attorney, which most states have, all states have. Our power of attorney, not that page numbers really matter, but our power of attorney is 30 pages long. Most of them that we see from other states are about 5.
Oh, wow.
I guess I should say our firm's power of attorney is 30 pages long. But it's because they're comprehensive. And the reality of a power of attorney is you're allowing somebody to step into your shoes and make any financial decisions for you that you would make for yourself. So it gives a lot of authority. You want to be as comprehensive as possible. And then our last one is a pre-need guardian declaration, which is pretty unique to Florida. I'm not sure I've ever even seen one come from another state. But this would be in the situation if you had none of those other documents or, had the wrong people in those documents. A pre-need guardian declaration allows you to pre-establish who would be appointed as your legal guardian. So if you are ever in a Terry Schiavo situation, you don't have somebody appointed for you. This would allow the court to say, okay, I realize that everybody's treated equally here, but she said she wants this person as her legal guardian, and then it's done and over with. So it
Wow.
kind of becomes a safety net to all the others, the healthcare and financial directives, um, in case we have to have a guardianship. Guardianship is not fun.
I don't know if you have an opinion on this, but if you do, I'd like to know. It
Sure.
do you think that it's beneficial or not to have the same person across all of those?
Um, I mean, I've seen it. I guess it really depends on who that person is. Um, I mean, there's not really, I guess, any real ironclad benefit, nor is there really any serious consequence to not doing it. I think it needs to be a very intentional decision for clients who are picking who's going to make healthcare and financial decisions. Don't worry about hurting somebody's feelings. That's something we hear all the time. Well, if
Yeah.
this one's going to be in charge of health, I'm going to make this one in charge of finances so they don't feel left out. Well, don't do that. Pick the one who's going to be the most responsible, who you know is going to follow your wishes. And then you can name other people as alternates. If you have multiple kids, pick the one that you think suits it best, and then pick an alternate. If this kid can't do it, then this one can. If this one can't, then this one can.
Yeah, I was actually
Um,
going to mention that there is a way for you to have like alternate people
yeah.
based off of different scenarios too,
Oh,
because I don't think that
absolutely.
people realize that either.
Yeah, absolutely. We encourage it. We have a rule of three. We would prefer that you have at least three people listed, have your primary and have two alternates, just to make sure.
Mhm.
Plan for what if. What if something happens? What if one of these people is your spouse and you travel with them a lot? What if something happens to both of you? So make
Right.
sure you have contingencies in place.
One thing that I would say based off of everything I've heard as well is talking to these people and letting them know that you've done that. Because I don't know how many times you've probably seen this, but like someone gets a call and they're like, I'm the beneficiary or I'm the person who has to make that decision. And they're
Yes. Yeah.
shocked.
Yes, we do encourage having a conversation about it, just making sure that they are up for the task. You don't necessarily want to pick somebody who has a lot going on or travels all the time for work, constantly overseas. You want to make sure you're picking somebody who's going to have the ability to make these decisions for you, be available for you, and who's willing to do it. You
Right.
know,
What
um,
happens if someone's like, I don't want to do that? Like what? Like can
they, yeah, they resign and it moves to the next person.
Okay, so there is an out. I'm like thinking to
Yeah.
myself, this is a contract, and they're like, no, like this is my person. Like, and they
No, no,
know.
there is an out. They haven't accepted the role. They're being named.
Okay,
But if they don't want to do it, then they can just usually, I mean, our documents will have the ability for them to step down and then it just moves to the next person who's named. So yeah,
okay.
they certainly
Neat.
can. But I agree with you. I think having the conversation and not blindsiding family members or other loved ones with this type of responsibility is a good idea. And it doesn't mean that you have to tell them the details. You don't have to say, this is how my trust is set up, and here's who's getting what, and the percentages, and this and that. It's just, hey, listen, we feel that you are best suited to make healthcare decisions for us, or to be our trustee, or to be our executor. If
Mhm.
something happens, call the attorney and you give them the card. Because a lot of clients shy away from having this discussion with family members because they don't want to tell them too much. They don't want them to know until they're gone.
That makes sense.
Yeah.
Yeah, interesting. I would say if there, I want to, I know I'm trying to be cognizant of your time, because
Oh,
you're
you're fine. I
a
have
lawyer.
until 12:30.
So a couple of other questions I had for you. One, you kind of touched on this a little bit earlier about tax mitigation. So
Mhm.
like I was thinking, a lot of our listeners, as they keep building their wealth and as they have heirs, you were talking about a step up and I think there's some of that stuff people know if they've really looked into it, but there's a lot of people who maybe don't. Are there some strategies or some documentation that they could put in place that really helps the heirs not to have such a heavy tax burden when they pass?
Absolutely. Trusts are the way to do that. 100%. There's the step up that we get in certain types of trusts we set up. Estate tax planning is the huge one. Right now our exemption is so high. Originally, when Trump was last in office, the exemption was supposed to sunset back to roughly 6-7 million January 1st. We are anticipating it's probably going to get extended, in which case, with inflation, our exemption is going to continue to grow. It's roughly 19 million per person right now. So fewer and fewer every year of our total population in the country fall into this category. But if you are a taxable estate, we have plenty of them. If you have 14 million, roughly just under 14 million is the current estate tax exemption for an individual, and compounded is 28 for a couple.
Okay.
So if clients have net worth of anything out over and above the estate tax exemption, there are certain tools that we can utilize to help plan for that. So their family is not paying a 40% estate tax.
Right.
And we use a lot of different tools depending on whether they're single or married. But there's a lot of different tools for that. There's planning for this, in particular for real estate investors. There's planning for double step up in cost basis for real estate. So Florida's not a community property state, but a few years ago, we did change our legislator and add the ability to have Florida community property trusts, which I know sounds weird since we're not a community property state. But we do have Florida Community Property Trust now, which we've been using quite a bit. So as I had mentioned earlier, if I leave my real estate to my kids upon death, they get the step up in cost basis when I die.
Okay.
If I set up a community property trust with my spouse, there's a double step up. When I die, my spouse gets the step up in cost basis at that time. So if they want to sell it, capital gains are minimized. And then again, when the beneficiaries receive the property, they also get a step up.
Oh.
So we're using that a lot more as a tool for our real estate investors, which has been working quite nicely.
No, that's like a huge thing, I think, that
Yeah.
people, especially if it's a newer development here in Florida. So I think that's like Chris needs it. I'm gonna like, okay, you gotta watch this because he's gonna have to tell people about it. That's really, really cool. And
Yeah.
is that something they do across the US or just in some states only?
That's a good question. I don't know the answer to that. I imagine in the community property states, they do have those. I know Alaska does. Um, I imagine all the community property states do still have some kind of community property trust planning like that. Non-community property states, I don't know if any of the rest of them are getting on board with that. They should,
Would you know
but
offhand, if they, like we were talking about earlier, when somebody has properties in several states, then
mhm.
are you still able here in Florida to then still add those in, or does it
Yeah.
have to be a physical property here?
No, it can be, we do planning with properties all over the country. So like if I was going to set up a revocable trust in Florida for somebody, I'd put their Florida property in there, their Michigan property in there, Ohio property in there, wherever it is. You can
Okay.
align property elsewhere with a Florida trust.
Okay, cool. That's okay, that's super neat. And then are there any other like big tax strategies that you would think we should take advantage of and or because of the recent shift in administration, is there anything that you anticipate coming out that people should be aware of?
We do expect the estate tax exemption to extend. We don't think it'll sunset January 1st. But I mean, the reality is taxes are a moving target depending on who's in office, right? So after the Trump administration and the estate tax exemption increase, one of the first things the blue team and the Biden administration wanted to do was reduce it back to 3.5, which was cutting it in half.
Right.
It didn't pass, but it's still sitting there. So if we do, next time there's a blue team in office, it could be brought back up again. So it's kind of a moving target, which is one thing we keep track of every 4 years, especially,
Mhm.
and try to plan for it as best as we can. I think I anticipate we're going to be okay for the next 4 years, that we're not going to go down, that estate tax planning is going to be easier going forward.
Okay.
But as we get towards the end of this administration, it's something that we'll keep a lot of track of. And we reach out to a lot of clients and say, hey, listen, here's what to expect. Here's what we think is going to happen. Here's the potential for what that means for you. Let's go ahead and take advantage of the exemption while it's high right now, because it is retroactive. If I do estate tax planning and I utilize my entire 14 million now, if the estate tax exemption changes, it doesn't matter. I used it when it was high. So they don't take that away from me.
That is something I was just going to ask you. So that's a very powerful, I think, piece of
Mhm.
knowledge to know is that that's a strategy that you can
Yep.
use to help mitigate your risk, your
Yep.
tax
Absolutely.
liability. Awesome. Well, my very last question for you before I let you go is we covered a lot. So I would say if there was one like key lesson that you want our listeners to take away today, what would it be?
um, don't shy. I mean, this is on a basic level. Don't shy away from estate planning. I know, like we said it before, nobody likes to talk about death. Nobody likes to talk about disability. It just sounds morbid. But change your mindset. Change your mindset to, I've created this legacy. I've worked my entire life for this wealth that I have built, and I want to pass it on for future generations. I want to protect and preserve and transfer my wealth to future generations. How do I do that? So it's not about I'm dying and my assets need to get distributed. It's about protecting your family, protecting your legacy. So I would encourage anybody who is shying away from having this conversation, just change your mindset. Don't think about it as, I'm dying, so I have to do this, or, I have to prepare for death, so I have to do this. It's not. It's protecting your family. And honestly, I would say, please, to all of you, stay away from the legal Zooms. No offense to LegalZoom, I'm sure they satisfy some, but from your dynamic of clients, my dynamic of clients, trust the process, go talk to an estate planning attorney. We offer a free consultation. I know a lot of attorneys, estate planning attorneys who offer a free consultation. So it doesn't cost you anything to have a conversation. Just educate yourself. Don't take it upon yourself to think, okay, yeah, I've done it. It's nice, easy, and simple. Have a conversation before you make decisions and just figure out what your options are, because there may be something that triggers a light bulb that you didn't know or you didn't think about, which I honestly get in almost every single one of my new client appointments. There's always something I say that they go, oh, I never really thought about that. So just take advantage of it. Attorneys are here for a reason. I know not everybody likes us, but attorneys are here for a reason. Estate planning attorneys are here for this reason. So use them. If you have somebody, if you have somebody in your state, if you need a referral, I'm happy to provide one. If you're in Florida and you want to have a conversation with me, perfectly happy to do that. It can be Zoom, it can be Teams, it can be a phone call. You can come to the office if you're local. But just make it a priority to at least start having the conversation, because it's not as bad as it sounds.
How would someone get a hold of you?
Email, you can call the office, Teams, Zoom, whatever the case may be. I wish I had a card next to me that I could throw up on the screen for you.
That's okay. If they just search, it's on here, we see Dorsey. So as long as
Yeah.
they search Dorsey Law, they'll be able to find you. And again, this
Yep.
is Erica Johnson. So just
Yep. Erica Johnson. I can give out my email if they want it. I don't know if you want me to do that, but
well, how about we will put your a link in the podcast for you. So we'll add a link, and if anyone wants to reach out to Erica, you'll be able to contact her.
that's perfect. Yeah.
Awesome.
Happy
Well,
to help.
thank you. And thank you to all of our listeners. I hope you guys enjoyed it and you got as much out of this as I did. I actually feel like I learned a lot again. So thank you, Erica, for your
Of
time.
course.
Have
Of
a good
course. I
one.
appreciate you having me. Yeah. And if anybody ever has any questions, click on the link, connect with me. I'm happy to share myself as a resource for any of you.
Awesome. Thank you.
You're welcome.
Thank you for tuning into this episode. We truly appreciate your support. Don't forget to subscribe, leave us a review, and share the podcast with your friends. Until next time.